Desma Nungo is the chairperson of the political party's Disputes Tribunal. And she's with us in the studio today. It's Thursday, hashtag Justice Thursdays. We have this conversation every Thursday, expanding access to justice, and especially from the information side of things. Desma, karibu sana.
Asante sana. A very good morning to you all.
Well, good morning to you. Welcome to the hot seat.
Thank you.
We call it the hot seat, but don't worry about the name. It's just make yourself comfortable on the seat.
I'm very comfortable and watching whether the temperatures will rise.
So what do you think? Are you a cat that is called to mediate between warring birds?
Allow me to call myself a dispute resolver. And I've seen an eminent dispute in this conversation. Save that I might not have the jurisdiction. As we'll be speaking, you will appreciate that mine would be limited to disputes arising out of political party affairs.
Okay.
Yes.
So tell us about that. The Political Parties Disputes Tribunal. What is it?
The Political Parties Disputes Tribunal is a quasi-judicial entity. When I say quasi-judicial, I mean a body that exercises judicial functions, but strictly speaking, it's not a judicial body. So it's a quasi-judicial entity that hears and determines disputes arising out of political party affairs. So it's established under the Political Parties Act with the mandate to handle such disputes.
So when you say quasi-judicial, does it are the decisions that come out of your tribunal binding, legally binding?
Indeed, they are binding, and they are also, in the event a litigant is dissatisfied with our decision, they can appeal to the High Court. So when I speak to the matter quasi-judicial, I need to bring to your attention that the tribunal composition is not just made of lawyers. Currently, the composition is such that there are a total number of 7 members as per law. So out of the 7 members, there is the chairperson, who is an advocate with the qualification of a judge. So currently, I am honored to serve the public as the chairperson of the tribunal. And then we've got a vice chairperson, who currently we have Honorable Dr. Mtubwa serving in that capacity. And then we have currently we have 4 additional members. So we've got Honorable Millie Luanga, we've got Dr. Adelaide Mbidi, we've got Honorable Gad Gathu, and we've got Triza Chepkony. So those are a total of 6. There's a vacancy for 1 position that is in the process of being populated. So out of the numbers I've mentioned, 4 are meant to be advocates, and then the rest are non-advocates, meaning they have specialization in different fields, whether it's political, administrative, just to give a rich mix of skills in dispute resolution insofar as political parties are concerned. So it's not the typical area where you see a judge is presiding over a matter. Yeah, it's a mix of skills, and everybody would listen and give different angles to the dispute and come up with an amicable way of resolving it.
How are members appointed?
The appointment of members is by the Judicial Service Commission. So it's an open and competitive process. Usually when there are vacancies or when terms of persons who are serving end. And just to mention, members serve for a term of 6 years, non-renewable. So when a member's term ends, or even a chairperson's term ends, they are advertised in the papers and also in the judiciary websites, and then applications are received by the Judicial Service Commission, interviews are conducted, and then appointments are made. Yeah, but later in this conversation, apart from the 7 members that I've just mentioned, you will appreciate that there were recent amendments to the Political Parties Act that now the impact it might have on us is that it's giving us 18 additional ad hoc members to support the tribunal. Yes.
18 additional?
Yes, and this 18, maybe just to understand, first and foremost, the quorum for the sitting of the tribunal is a minimum of 3. So meaning out of the 7 members, we can only have 2 panels sitting at any one given time. Now, with the addition of 18 or so ad hoc members, it means now we can expand the number of panels that are sitting. And that, of course, would enhance access to justice and, of course, aligns itself with the Chief Justice's vision on social transformation through access to
18
justice.
plus 7, 25, so you can actually have eight panels sitting at a go.
At any one given time, indeed.
And is the just as you're looking at, obviously this is planning, right?
Yes.
With the addition of these 18, it's planning with the mindset that there will be more disputes that would come in terms of volume.
Yes.
Right. So is the expectation going into this period that we're likely to see more come to the door and say, look, we need this sorted out? Is that the expectation?
Indeed, that is the expectation. And this increment in the numbers was informed by lessons learned. For example, in 2017, we did not have provision for ad hoc members. So it means that in 2017, we only had 2 panels sitting at any one given time. Now, in 2017, we had close to 600 disputes in a period of barely 2 weeks. Because remember, as the tribunal, we work together with other institutions like the IEBC, and we expected to ensure that we make our determinations within the timelines that have been gazetted by IEBC for purposes of clearances for electoral processes. So it therefore means that in 2017, there were only 2 panels sitting, and this overstretched the tribunal because we had to sit all days, all nights, including weekend.
Wow.
And it was very, very tiring, especially for our litigants who even had to travel from all over the country to come all the way to Nairobi. So lessons learned from this then made us call for reforms with a view to ensuring that during this busy period, because indeed pre-electoral dispute resolution period, the period we are currently approaching, and you all appreciate that political parties are gearing themselves towards conducting their party primaries. Yeah, there is an increment in the number of disputes, and we therefore want to just enhance access to the tribunal, and this will also enable the tribunal to decentralize its services. So we don't all have to be sitting in Nairobi. So we have therefore identified regions where we would also be venturing into with a view to ensuring that at least we are more accessible than we've been in the past.
Yes. What is the nature of some of the disputes that come to your table?
Okay. There are of various dimensions, but the law defines specifically the kinds of disputes. For example, it would say if you have a dispute between a member and a political party. So I am a member of Party X and I have a dispute, for example, in the manner in which they're interpreting their constitution. You know, all political parties have constitutions, and constitutions are like the contracts they have with their membership. So pursuant to the constitution, the membership expects certain things from the political party, and in the same breath, the political party also expects certain things from the members. So in the event that there is breach of constitution, for example, you said that you are going to conduct election of NEC officials, but it has not been conducted. You said that we are going to be having meetings, and this is supposed to be the quorum of our meeting. These are the persons that we expect in these meetings. But now you have decided not to conduct this meeting, but you have nevertheless come up with resolutions for the benefit of the party. So there are various dimensions that come applicable to the moment at hand, nominations. You know, nominations politics have become very, very competitive, very heated, very emotive. In fact, normally they say land is an emotive subject. But from my experience and any other Kenyan's experience, I think politics is also more emotive, very competitive. And we appreciate that at the stage of nominations because you will know that there are regions where a nomination is as good as an election. So if you win that ticket at the stage of nominations, you're good to go. So it becomes very, very hotly contested. And that is why at PPDT we take pre-electoral dispute resolution very, very seriously. We want to conduct it efficiently and effectively, because you remember prior to the Constitution of Kenya 2010, a typical example, 2007, there was a lot of violence, there was a lot of dissatisfaction with processes during nominations. So much was going on within, but there was no organized forum where the pre-electoral issues would be addressed. So people had to wait all the way up to the conduct of an election, the declaration of a result, then that's when they would file election petitions in court. But now pre-electoral dispute resolution fora have been made available, and it's not just the tribunal, even IEBC plays a role in pre-electoral dispute resolution.
But it's within a very short time. Do you have sufficient time to actually hear all the disputes that will be lodged before your tribunal before an election? So say party nomination, party primaries are going to take place, in April, May. And then the satisfied parties then come and make their applications before you. Do you have sufficient time to adjudicate?
Yes, we create that time, but even as we create that time, we also conduct what is called active case management. Because, if you have very many matters and you are supposed to determine them within a particular period, and everyone expects your service, then you've got to at least treat everyone equally by giving them, for example, trying to balance what time you're giving to each party, and also encouraging parties to put in written submissions in support of their respective positions. So indeed, we create time because we don't have an option. We are called to undertake that role, and Kenyans are expectant that we've got to undertake it.
Do you also deal with disputes between parties? Because what I'm hearing a lot is the disputes within parties. So a member versus the officials of the party, officials versus one another. How about party versus party?
Yes, we do.
Like?
We do, for example, a dispute between parties would play, for example, in the instance of funding, parties, or in the instance of a coalition, where political parties are coalition partners, and they have this agreement that makes provision for how they are supposed to relate, but then a particular party perhaps does not honor that side of the agreement, and so they are then called upon to have it settled in one way or another. So political party funding, where there's funding that has been distributed, and parties amongst themselves are contesting how that has been undertaken. So we hear disputes between political parties, disputes between a member and a political party, disputes involving coalition partners that I've already said, disputes between an independent candidate and a political party, and also appeals arising out of decisions of the registrar of political parties. Yes.
You mentioned that you want to devolve these services into regions. How many regions do you hope to have these services available?
Okay, currently we have identified and indeed set up ourselves in 7 regions, if I could mention them.
Please.
So we've got Nairobi, we've got Mombasa, we've got Eldoret, we've got Kisumu, and then we have Nyeri and Meru. Actually, those are the regions that currently we have put structures in place. And of course, as a tribunal, we'll be working closely with the bigger judiciary structures, at least getting to centers where they're already well established and has the necessary facilities, because we are all fed from the same source in terms of the exchequer and the judiciary. So we are working within our means, but at the same time ensuring that there is that access to everybody.
Can I ask what the rationale for determining these particular places was?
Okay, this was informed by what we saw were the patterns. For example, in 2017, there are areas where are known or called like hotspots for particular parties, and that goes together with also aligning ourselves to the current trends, where we expect disputes to be on the increment, looking at the current political parties that are there, their structures, and what's going on. So there are various dynamics that inform the same, but just to mention that it will be a process that will be ongoing, so that in the event there is need perhaps for a panel to even have presence in another region because of some matters that would come up, would be able to make necessary adjustments. Remember, we are 25. So it means we would still be having extra people who we can just put in place to support.
Okay.
Yes.
When you look at patterns, are you talking about the number of cases that one has seen emanating from these areas over a period of time?
Yes.
And or are you also, oh, you said yes, okay.
Yes.
So are we also considering perhaps, because the centers seem to be more regional, as in cases that emanate from that particular region will end up in that particular place? Because you see, when you mentioned Meru, I immediately started thinking of northeastern.
Yes, indeed.
Yes. And I'm thinking, yes, one in Nyeri, I understand. Northeastern. Because the question I would ask is, aren't there enough cases coming from northeastern so that, in my mind, it appears that the cases that would appear there would have to be taken to Meru? Is my thinking correct?
Yes, your thinking is correct.
Yes.
And in fact, what I need to, the judiciary has embraced ICT a lot, especially during this COVID period. That's when virtual courts came into effect very, very significantly. And as the tribunal, we also took up that and went on with the virtual courts. And a report that I usually share at any opportunity is that pursuant to the introduction of virtual courts, at the tribunal, we registered the highest number of matters that were filed from that northeastern region because it made it much more easier for lawyers from those regions to serve their clients at the comfort of their offices. You are looking at me as though there is no network in Northeastern, but from our experience, we registered the highest number of matters coming from that region filed virtually. So yes, indeed, that is the intention. Yeah.
No. I'm delighted to hear what you're saying, because it then means that connectivity in this country has actually literally gone throughout the whole country. But then I have to ask, because when you talk about Mombasa, I'm thinking of Mombasa County, I'm thinking of Kilifi County, I'm thinking of Tana River County. And so all these cases would also then be served in Mombasa.
Yes.
I have to ask, the connectivity in some of these areas that I've mentioned, Mombasa, I understand. Is it as good as the one we have in the northern part of the country?
It might not be the same, but remember, we will not be just going virtual only. It would be a hybrid where there is need for physical presence, because these panels will be located in those regions as the center place for their operations. So for those who would be able to link in virtually, they would. For those who would want to come physically, it would also be open for them to come physically. Remember, I have mentioned our numbers.
Yes.
We can only stretch to a particular extent.
Yes.
And it's a very, very big improvement from where we started,
Previously were.
where we were at 2 panels only. So now we are going to be at most 8 panels. So this is a big step, and we will be observing how processes go, but we hope that it will be less strenuous to our litigants who had to sit day and night at the court corridors, even becoming a security threat. Some did not even have transport to come all the way, or if they had transport to come all the way, they would come and then they would not have transport to go back. Some would not have accommodation. So because the proceedings were going on day and night, they just decided to station themselves there until they finished their matters. So there are a lot of dynamics to this. Remember that not every Kenyan can afford legal representation. So there are those who had to come in person to represent themselves. There are categories of persons who are abled differently, who also are entitled to access to justice and also needed these services. So there are lots of dynamics in play, and we are looking into all this to just enhance that access and at the same time improve on our efficiency. to the public.
There's a lot to talk about, especially when you now bring in the other angle, because we're talking about political parties and disputes. You think about the big guns in a party. You
Yes.
think about, okay, so YPI is complaining and ANC are complaining they have not received money from the political parties fund, and they are taking ANC, ODM before the tribunal. Then there are other issues where it's ordinary members of parties who are taking an issue against the party. And those also have got to be treated equally.
Yes.
Let's talk about some of those examples that you have dealt with in a
Yes.
couple of days after this break.
Spice.
The conversation continues. Hashtag Justice Thursdays, where we discuss about improving and increasing access to justice. This time we're talking about what we expect this season. It's a political silly season. It's a time for everybody to complain about their treatment within or outside or by political parties. So the chair of the political parties dispute tribunal, the Honorable Desma Nungo, is with us in the studio. She's telling us what the tribunal does, how they go about their business, what they've been doing so far, what kind of disputes they deal with. So disputes within political parties where it's, one person who says we have ousted so-and-so as the chair of this party or the party leader. The other party leader comes and says, but I am still the party leader. Mnafikiri mimi si Simba, mimi ndio Simba kamili. And we know what we're talking about. So you don't mention it, but we've seen in the media. We saw, for example, the dispute between Ford Kenya, factions within Ford Kenya. Those ones came before you, right? Or did they not?
Well, yes, there were cases involving those particular parties before the tribunal. Indeed. Yes.
And you went through the entire sitting and came up with a determination.
Yes, we went through the entire sitting, but I must say that there's an angle of it that was subjected to the appellate processes, and I'm not too sure whether the matter is still pending before the courts. But just to make mention that yes, such disputes come before the tribunal, and you will allow me not to delve into the details in light of the pending proceedings.
Definitely. We just wanted examples. So that is an example
yes,
of
that
a
is an
matter that you've
example.
handled.
For example, wrangles within the party on leadership. I am supposed to be the duly recognized, for example, Secretary General of this party. But at some point, there's some process that is undertaken and somebody else is elected as the Secretary General. Then the group rushes to change particulars at the registrar of political parties. So you'll get that there are two factions that would be engaged in a dispute revolving around who is the rightful office bearer for purposes of the political party.
Can the tribunal, okay, you said you're quasi-judicial. Can the tribunal issue injunctions? So, for instance, there's an expected national delegates conference that has been called by Party X.
Yes.
A certain person believes that they should be a delegate
Yes.
and they have not been called to attend this. Can they come to you and say, please stop the delegates conference? And you actually do so?
Yes, they can come before the tribunal because remember that would be the category of a dispute between a member and a political party. And this member would be this delegate who feels like they had a right to attend this, but they have not been notified. Or if they have been notified, the notification has not been done procedurally in accordance with the party constitution, where, for example, they would say that there was no specification of the agenda of this particular meeting, so it's therefore not clear what the subject of the NDC would be. You've seen some saying, especially in the current event, some even say that the agenda did not speak to decisions to do with the party's presidential candidate.
Yes.
And so they come before the tribunal. And yes, when a matter is urgent, the tribunal has the powers to certify a matter as urgent. So you would move the tribunal under what is called the certificate of urgency, and the tribunal has powers to issue interim orders with a view to ensuring that the subject matter of the dispute is not overtaken by events. Because if your dispute revolves around the NDC and it's coming up in a week's time, and yet you've moved the tribunal and the NDC goes on, so it would mean that you'll be left with nothing to litigate on. So where based on the discretion we exercise our discretion based on the record that is presented before us. But where there is justification, we normally grant those orders. Where there is time to hear both parties first, we also explore that, so that in the interest of justice, then we hear from all parties before granting any orders concerning, for example, the matter of the NDC or any other matter that may arise. So indeed, we have those powers, and our powers even go beyond issues of compliance, because at the end of the day, when you come before the tribunal and the tribunal grants an order, you expect that there is compliance with that particular order. Otherwise, then it would be a waste of taxpayers' money to have a tribunal constituted and to make determinations that are not respected. So with a view to just building on the probity and integrity of the tribunal, the law grants the tribunal powers to enforce its decisions in the same way that you do the enforcement in a magistrate's court. But now with the current amendment, what it says is that the tribunal even has powers to punish for contempt in the same manner that a high court would be exercising such powers. So, yes.
How would a political party, for example, given as a player here,
Yes.
be punished, for example? And then how do you then insist that this is done? Because, I mean, I understand what you're saying, but then I also see the way politics plays out in the country. And it would seem as though the political party is the almighty vehicle and that they cannot be touched because, by and large, it goes by the whims of an individual. So those are the mechanics that we are looking at. And then we're now looking at the law, which essentially would insist that a certain thing is done in a certain manner. Who is punished? The party as an organ or an individual who leads? An example of how then an order then would be enforced and then punishable if not followed.
Okay, so when you're speaking on matters political party, it's a corporate entity, let's call it as such.
Yes.
And behind a corporate entity, there are individuals who are expected to execute certain functions. For example, there are roles that are expected of a Secretary General, there are roles that are expected of a chairperson, amongst others. So depending on the subject at hand, an order would be directed towards performance of a particular action by a particular individual. Just like you say, for example, in matters involving the government, you will see that maybe it's the cabinet secretary for a particular ministry that is put to task to show cause why they should not be cited for contempt for failing to obey certain orders. So I must say that yes, there are persons who you could push towards compliance, and it's a journey in terms of institutionalizing political parties.
Right.
That bit I agree, but I must acknowledge that we are from very far. We are moving steadily towards changing the narrative. The steps are slow, but there. So there's still so much work that needs to be done, and that is why even at the tribunal, one thing I also need to bring out clearly is that before an individual files a dispute before us, the law requires that they exhaust the internal mechanisms of dispute resolution within the political party. If they do not subject the dispute internally to the party, then pursuant to the law, we do not have jurisdiction. So this is intended to just strengthen the capacity of political parties. There are various dynamics to it. Political parties have dispute resolution mechanisms within them. But then again, we appreciate that there are instances where the parties themselves might frustrate persons who are aggrieved, and they might not probably handle disputes in a manner that delivers justice to the aggrieved party. So where such scenarios play also, we look at the circumstances and assume jurisdiction.
When we talk of disputes, I'm curious.
Yes.
Are there certain disputes that are common? Are there disputes you come across more often than others? Are there others which are rare that only appear every once in a while? Or are they all the same?
Interesting. Well, the categories of disputes are common, but in terms of now the uniqueness, it depends on each particular case. But generally during nominations, for example, the disputes that would come up were like the party called on us to pay fees for nominations, but they ended up not conducting the nomination process. They gave a direct ticket to somebody
After people had paid.
after payment. So then they would come before us, and so we would want to look into what was the legitimate expectation by virtue of accepting payments from people. Was it just to accept payments without conducting the process as per the party constitution? Other examples would be our constitution expects that the elections board should, for example, do A, B, C, and D, but they did not do it during the nomination exercise. Or the nomination, there was no proper register in place. You know, registers are a hot potato, both at the electoral, national, and even at nomination, party nomination levels. And even now, you see that in the amendments to the Political Parties Act, they say that the registrar of political parties should at least ensure that the membership lists are in place, and then they are the same lists that now would be used for purposes of nominations. So that if your name is not listed, then ordinarily you're not supposed to participate.
in a
Yeah. So there's so much work that needs to be done in terms of just institutionalizing. We know there's still a bit of patronage playing along, but now it's not just in the open. It's being done very cautiously, and we see that there is some growth, and we look forward to at least more improvement at some point.
How do you enforce outcomes that you have determined ought to be put in force? How do you actually enforce it?
Okay, so it would depend. For example, if it involves payment of some sums of money, that one, there are different ways you can attach. You can attach, meaning you can attach the person. You can have somebody arrested for not paying up.
Arrest
you
and,
can
and
have
attaching is the same thing.
Yeah.
So when you attach a person, you've arrested them.
So you can attach a person. You can also attach property,
Yes.
where you normally see that they go and proclaim people's property, and then they come later and take them up. So there are different forms of doing that as recognized by law.
There's something that you mentioned about the registrar of political parties.
Yes.
So disputes between members of party and the registrar. What kind of disputes would you be dealing with? So let me give you an example. You can tell me whether this works. Many people have lately been talking about going online and finding that they are members of a certain political party and they have never registered for such a party. So who should they be complaining to? The party, the PPDT, or the registrar?
Okay, there are different dynamics to it. There could be the direct one of complaining to the party. But there's also the option of, if, for example, they write to the registrar and tell them that we have found our name here and we are not members and we expect you to assist in resolving this. And then the registrar makes a resolution, yeah? So that resolution is subject to appeal.
Okay.
Yeah, so that would come as an appeal now before the tribunal. Another example of appeals that would come from the decisions of the registrar of political parties, you remember parties have been doing a lot of changes within their structures with a view to preparing themselves towards the general elections.
Yes.
Some of the changes would be who are the office bearers, who are the members of the various organs, which colors do we want to maintain, do we want to change our symbol, and they have been applying to the registrar who puts up notices in the Kenya Gazette of such change of particulars. So there's a process for change of particulars of a political party, including even change of the party constitution. These have been ongoing, and there have been various applications in that regard. So let's say a party makes that application for change in particulars, but for one reason or another, when it's subjected before the registrar of political parties, they decline. It could be for any reason. Perhaps the party has not attached minutes showing the resolutions that were arrived at in making those changes.
Changing from a handshake to a dove.
Yes, and yes, it's such like things. And has even informed, and most of the times what the registrar does is she engages with the political parties so that where there are issues that need to be attended to, she makes them attend to them. But there are instances where sometimes there is that engagement, but the party has still not complied, and in one way or another, the registrar has to make a decision. So in this case, then a party who is aggrieved by that decision can now file an appeal at the tribunal. So we've had instances where a party, for example, is deregistered. The registrar puts up notices as required of the law, and it gets to the point where they've got to do the deregistration, but then this party now learns that it has been deregistered and they feel aggrieved by that deregistration, so they appeal against that decision, amongst others.
Okay, so would you say that in how adjudication has been going over these disputes in the recent past, are you comfortable with it, with the resolutions that have come about as a result of these disputes that have come to you? Are you comfortable with the way things in which they have been going? Parties who've been aggrieved, have they been able to find, the resolutions fair? Because I'm sure this feedback then comes to you. Are you comfortable with that, and comfortable with how those who bring their issues also are feeling?
Okay, what I can say is that we know that the decisions that have come from the tribunal up to the appellate courts have shaped how political parties conduct their processes. Even if there is something that they want to do, they would want to try as much as possible not to find themselves on the wrong side of the law. So it has indeed impacted. Of course, there's still much more work that needs to be done within the party structures, but I can see that there is some positive steps towards that what we were calling institutionalization. And also what I also want to say is that insofar as what is brought before us to determine is concerned, we determine it fairly based on the facts and the documentation that is presented before us. But there could be instances where a litigant is dissatisfied with our determination for one reason or another. So the law allows them the right to appeal against our decision to the High Court. Yes.
And do we see a lot of this? A lot of these cases then being wrapped up in appeal? Because essentially what that, as you say, appeal is an indicator of dissatisfaction.
Yes.
With the resolution that has been arrived at.
Yes.
So do we see a lot of this then being wrapped up in appeal? Because then it means that we have months and months of these issues, continuing, and then you have to ask then about processes that political parties ought to be involved in. Those seem to come to a stop or come to a halt because we're waiting for the adjudication of these disputes.
Yes.
Is that what we are seeing? Or, are we seeing that less and less are going to the appeal stage and are just, taking the resolution that has been granted and then going with it?
Well, what I can say is that, number one, litigation or dispute resolution at the court or the tribunal, it's a win or loss. To some extent, one person will always feel like they have lost.
Aggrieved, yes.
And the other person, of course, would feel like they're successful. So then that would mean that everyone would want to try at another level to see whether they can have it in a different way. So to respond to that, yes, there are appeals that are filed against determinations of the tribunal. There are a number that have been upheld in terms of maintaining the tribunal position. There are also others where the court have viewed things differently and made different determinations that depart from what the tribunal determined. So all this is about growth in jurisprudence because it's about and Kenyans have a right to exploit to the extent that they can. Of course, it boils down to time, and harmonization of timelines, especially during this electioneering period, has been a major challenge because we've got to rush with so much and ensure ensure that we are done before, for example, IBC's deadline for submission of names of candidates comes into place. So it means there is a lot of rush between these. Remember, you are starting from the party internal dispute resolution mechanism. That's what we normally call the IDRM. Then you go to the tribunal. Then you can go to the High Court. Then you go to the Court of Appeal. Yeah.
Something I want to ask. Court issues, from what I understand, always have to do with paying court fees.
Yes.
So in these matters of resolving dispute between political parties and issues within political parties, they also pay fees. Is it the normal fees that people pay, or has an arrangement been made for them to pay a special fee?
Now, at the tribunal, there is the fee, subsidized, I would call it subsidized fee, that is payable for filing matters at the tribunal. So what normally happens when you go to the tribunal offices and even the website, there is a service charter that is displayed out there. And within that service charter, it tells you, still furthering the CJ's vision on social transformation through access to justice. Yeah, and one of the guiding principles within it is transparency and accountability. So it's transparent. You know that if you go before the tribunal and you have this particular prayer you are seeking, this is the amount of fee you're going to be paying to the tribunal. So it's a very open, very transparent process. So there is no other fee other than what is prescribed within
what is written there.
What is written there. That would be, and usually the documents are presented. If you present them online, actually they're able to assess it and invoice you. If you go physically, also they're able to assess it and just give you an invoice, and then you present the payment. There's the judiciary accounts where payments are made through the banks. Then you come with the receipt. And then the case is now registered completely. Within political parties, they also have their own mechanism. So all these are guided by the party constitutions. From our experience, we've seen some political parties who make provision for some fee for filing a claim within them. Some don't make any provision. So meaning if you have any complaint, just present it.
What happens if you can't afford to pay this fee?
If you can't afford to pay filing fees, just like in the judiciary, there is available what is called the POPA mechanisms, where you file a request. You can do a letter, and then it is assessed within the civil procedure rules. And if it is established that you are one that needs that kind of support, then considerations would be made in that regard. So there is also room for that, but based on assessment.
It has to
but
be assessed.
we would also need to look. We would also need to look. You are going for this particular position. We know, politics is not.
Nomination fee.
Yes,
and now you're saying
and
you can't
now you
afford
cannot afford
tribunal fee.
minimal
You
fees
finished.
for
See,
filing.
the
First
money
time you're na chama.
Yes.
Desma Nungo, thank you very much for joining us. Desma is the chair of the political parties dispute tribunal. We've been discussing that, and I mean what it means for the political parties dispute tribunal to be in place. Asante sana for joining us.
Thank you very much. It's been a great conversation with the entire team.
Asante.
Thank you.